Hi everybody, this is Arkady Frekhtman, a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. So let's get into it. The next comment is from a Mike Cook, and he says, the treatment ends 6 months after the accident. The independent medical exam is conducted 1.5 years after the accident. The trial happens 5.5 years after the accident. Are the arguments presented during the trial based on the documentation collected in the first 1.5 years? Is the plaintiff during trial allowed to say that he is still in pain? So I guess what he's saying is that because everything takes a long time, how do we deal with that? So basically, the treatment doesn't always end 6 months after the accident. In a typical car crash case, if it's a soft tissue case, yes, usually the treatment will be from 3 to 6 months and then it'll end. But if it's a more serious injury where, for example, somebody needs surgery, somebody needs injections, that could last longer. A client could be getting treatment even 2 years, 3 years after the accident. Now, the independent medical exam, is conducted about 1.5 years. It's hard to say exactly post-accident. It depends on when the lawyer files the lawsuit. Usually it's conducted as part of the lawsuit before putting the case on the trial calendar. So that's one aspect of it. Now, the trial happens 5.5 years. Also it depends on the jurisdiction. Sometimes the trial happens much sooner. Sometimes you can get a trial in like 2 years or 3 years. But to answer the question, no. The arguments presented during trial are not based only on the first 1.5 years. They're really based on the future of your entire life, right? If it's a permanent injury, if it's a serious, life-changing, forever injury, then you're going to want to have medical records, and you're going to want to have evidence, either with before and after witnesses like friends, family, co-workers, neighbors, as well as doctors, to show that this is a life-changing, forever, permanent injury, and it's going to be for the rest of your life. That's going to make the value of the case much, much higher, right? Because if you only say it's for 1 year, okay, it's a year worth of suffering, then that's known as the past amount that they can give you for pain and suffering. So if you're going to trial and you're only claiming past, you're probably not going to get that much, because they're going to say, okay, the accident happened, let's say, even 5 years ago. So the person was hurt for 1 year, maybe 1 year and 6 months. Okay, well, 1 year worth of pain, let's give him, $50,000 for that. And there's no more. It just stopped all of a sudden. So the other 3 years we've been waiting is just a delay because of the court system. And for the future, even if the person is like, say, 30 years old, for the future, from when they're 30 until they're going to be like 85 the rest of their life, it's worth nothing, right? Because the injury all resolved. That's going to be a really low value case. So most plaintiffs' lawyers are not going to prepare a case that way. They're usually going to be able to say that the person is still treating. Now, they might not be treating as much as they were before. At the time of the crash, they were treating, let's say, 3 times a week with physical therapy. That ends after 6 months, yes. But now the person can just go to a specialist, let's say go to pain management and do injections, or just go to an orthopedist and get a follow-up. And you could do that maybe once every 4 months, right? Which is 3 times a year. You could do it once every 6 months, which is only twice a year. You could even do it once a year, but make sure that you do it as an injury victim, right? Because if you don't treat at all, then you're probably not going to be able to get future pain and suffering. So don't stop your treatment. Just go like even once a year, and then you could be able to get future damages. So that'll make the case much, much better, bigger and much, much better. So I hope that answers the question. But that's a good question, actually. And that's one of the things that, plaintiffs' attorneys have to think of, because the cases take so long, which isn't really our fault. Like, if we could, hey, I'd process a case in a month, right? Let's just do depositions. You do deposition in like a few hours, put it on the trial calendar. If it's possible, let's just try the case. But you can't, right? Because sometimes you file the lawsuit and the injury is not done yet. The person's still treating. Sometimes, it just takes time. Like, you file a lawsuit, by the time they appear in the case, that takes like a month or two. Then to get a preliminary conference, that takes a month or two. Then you get your conference, but usually in discovery, there's some issue. They're not giving you documents, so you have to file a motion to compel the documents. So it's just going to be a delay. That's just something that's unavoidable. But does the delay mean that you should just be like doing nothing? No, because then that's going to kill your case. So you still have to be getting your treatment. Okay. And there was another video. This one was called Silence, what you can't and what you can and what you cannot say during a trial. And again, Mike Cook says, at cross-examination, can the plaintiff's attorney ask the old lady if she hired her lawyer or if he was provided to her? Oh, I see. So what he's talking about is, in this video, I talk about the fact that, let's say you're suing for a car crash and an old lady crashed into you. The defense is going to make it seem like this old lady is the one paying the money, as opposed to the insurance company. Because as a plaintiff's attorney, you cannot mention insurance. So he's saying, can you ask the old lady if she hired her lawyer or if one was provided to her? I don't think so. I think most judges would probably sustain an objection about that, because how she hired counsel, and that's privileged. So you probably can't ask that. Then he says, can the plaintiff's attorney ask the doctors and other expert witnesses testifying on behalf of the defendant whether they were hired by the defendant or someone else? Yeah, I mean, that you can go into. You can go into, for example, who hired you, has the defense law firm used you before, how much are you charging for your testimony? So there are ways. You get past transcripts on them and you can impeach them with their past transcripts. So there are many different ways where you could show bias, and you could show that these expert witnesses being hired by the defense or by the insurance company are not truly objective and impartial to both sides, but rather they're like a hired gun. Sometimes some lawyers even say they're like a jukebox, because you come up to the jukebox, you pick the song that you want to play. Well, first you put in the money. That's important. You have to put in the money, right? Otherwise it's not going to work. Then you pick the song that you want them to play, and then they just play that song, which is kind of a good analogy for these defense medical experts. Okay. Then Cousin Rick says, I was hit by a car in Brooklyn, New York, who blew a stop sign and was seriously injured, had back surgery and neck surgery, and it is now 2023 and still nothing. Yeah, well, it sounds like it should definitely be a big case, as long as the car that hit you has enough insurance, because, a back surgery, a neck surgery, that's a very, very serious injury. So that could be worth millions of dollars. Important thing is to build the case correctly. So, feel free to text us, 347-566-9595. Happy to give you a consultation. Just chat about it, see if we could help, or maybe just give you some free advice. Okay. Let's see what other questions we have. Here's a question. How about the medical facility? I have a herniated disc, been out of work since October of 2022. I was sent to a medical facility that my work uses. They do not do x-rays, MRIs, nothing, but felt me for about 10 minutes and sent me to physical therapy 3 times a week. Then they cleared me to go back to work. I started having even more pain and I went to a doctor myself, where they did the x-ray and MRI and found a herniation. And I'm in workers' comp, but can I go after the medical facility for what I feel is clearly malpractice, especially with someone coming in with reporting a neck injury? I'm located in New York. Yeah, I mean, feel free to text me. I'm happy to help. I'm happy to speak about it. I don't think most likely you're going to be able to sue the medical facility. And the reason for that is that if you already got into, let's say, a work accident and you had this herniation, the only thing that the medical facility did wrong was that they didn't diagnose it, but you already had the herniation, right? So had they diagnosed it, you would have just known about it earlier. But the medical facility's mistake, right, their negligence did not cause the injury. The injury was already there. They just failed to find it. So another facility did find it. So that delay, I mean, you could argue, but I would say probably, I don't know what the underlying condition is, the underlying incident that led to the herniation. Was that a car accident? Was that a work accident? How that happened. Is it straight workers' comp? Maybe you have a third-party lawsuit, but that's the case that you can sue for. And the intervening or the medical negligence, that just happens. That's known as a foreseeable part of somebody's treatment. That's just something that happens. But the underlying injury is a natural sequelae of the first event, right? Whether it was a car accident, a slip and fall, it doesn't say in the comment. So you could just sue for that. You don't need to sue any mistake. People always want to sue doctors, but it's really hard to sue doctors. Really, the only time you should be suing a doctor is when it's a clear mistake. The mistake is what caused the injury, nothing else, right? And, it's just, even then, I mean, it's very, very difficult, but it has to be a very permanent and very serious mistake on the part of the doctor. Suing doctors is not easy at all. You need to get experts. You need to get your own doctors who are going to come to court and testify, right? First, they're going to have to review all the records and find all the mistakes and say that those are mistakes that are basically against good and accepted medical practice, and that those mistakes were a substantial factor in causing all your injuries, right? And you're gonna have to pay them for that review. That's probably gonna be like $5,000 or maybe more. Then they're gonna have to come to court, and that's gonna be maybe like $10,000 or even more. So you could be spending like $50,000 on a medical malpractice case. It only makes sense if it's a really serious injury. A lot of examples of medical malpractice cases could be birth injuries, right? Erb's palsy, cerebral palsy, brain injuries, like things like that. I had a case a long time ago where a child became blind because of medical malpractice. And even though the delay was short, it was like 4 to 6 month delay, the fact that there was a mistake and we had an expert, we were able to go to court, and we ended up settling that case for many millions of dollars. So things like that. We had one case where it was extravasation, where they were trying to just inject, set up an IV, something simple like an IV, and it leaked into the soft tissue, and it really burned the lady's hands, and she had permanent scarring. That also settled for many millions of dollars. So cases like that, but something like just not finding a herniation, that's not going to be malpractice. I mean, it could be academic malpractice, like it was a mistake, they should have found it, but it's not what caused the injury. The injury was already there. So I would say go with the underlying event, whatever the first event was. That's always better. Okay, and then we have a comment from John. He says, I know why all cases settle. The insurance companies make the rules. And if you don't like it, too bad. Well, yeah, you have to fight back. That's the whole point. You have to be strong. If you just let them make the rules, they could say, look, you have a fusion, you have a brain injury, I'll just give you a penny. How about that? I'll just give you a penny. If you let them make the rules, they'll just call all the shots. So you have to fight back, you have to go to court, you have to get verdicts, and that's how you command more money, because then they get scared of you and they start paying you. And they have tabs, they keep tabs on all lawyers. They know which lawyers just settle and play the volume game. Hey, I'm gonna settle a bunch of cases, each one for $3,000, but I have so many of these cases because I have billboards up everywhere, right? I'm advertising. I'm just gonna settle each case for $3,000, but I'm gonna make my money that way. That's one type of lawyer. And another lawyer might say, look, I only have this one case, but I'm really gonna dive into it. I'm gonna call all the doctors, I'm gonna work it up, I'm gonna speak with the client, I'm gonna learn their human story, I'm gonna go to trial, I'm gonna be fearless, and I'm gonna get, 10 million on this one case. So it's just the way that you approach it. Okay, I hope this has been helpful. Let us know what other questions you have, and we'll do more videos where we answer your questions and we talk about your comments in Last Week Tonight. Okay, everyone. Talk to you soon. Bye.